It's very satisfying to help people. I just can't imagine a better job.
Good evening. My name is Bonnie Cram. Welcome to the presentation tonight, the 4 advantages of using trusts as opposed to using wills. I'm a lawyer with the Ettinger Law Firm. It's my pleasure to be here to talk to you about a very interesting topic that I love to talk about almost as much as talking about my children and grandchildren, but not quite. So it's a very rewarding area of the law to work in, and I did not go to law school until after my children were in college, so I feel very privileged to be in a field that is so helpful at a firm that is so helpful. Michael Ettinger started our firm 30 years ago and decided to do only elder law and estate planning, nothing else, so that's all we've done for 30 years. We've done over 25,000 estate plans. Just a little bit of housekeeping. The webinar takes about an hour. I will take all the questions at the end. You'll see on the bottom of the screen that there's a chat button that you can type questions in, and also Q&A button where you can type your questions in. Now there's another button or tab, whatever you want to call it, that says raise your hand, and I can see you're raising your hand, but I can't answer you live. So tonight is basically a litmus test to see where you are with your planning goals, if you have any, and maybe inspire you to have some planning goals. You can see on the screen there that we have offices in quite a few counties in New York State. We have 14 offices. And tomorrow we email you a recording of tonight's webinar if you want to listen to it again or listen to it. We also will email you tomorrow a pamphlet. It's an e-booklet called Elder Law Estate Planning in a Nutshell. Michael Ettinger wrote it. He's a very good writer. It's easy to understand. It's about 12, 13 pages, and it's a synopsis of the book he wrote called Elder Law Estate Planning, which we give you a free copy of when you come in to meet with us for the initial consultation, which is absolutely free. So this book is in plain English. The booklet that we'll email you tomorrow is a good synopsis of that book. Let me just make sure I've gone over the important points. Yeah, I think that's it. So let's get started. We sent you the PowerPoint presentation. I'll be going through that right now. What is elder law estate planning? There are a lot of misconceptions about that. It's actually very specific. It's an area of the law which combines the features of elder law, which is disability planning, meaning making sure you've named people who can make decisions for you, protecting assets from going to nursing home costs. These are things like the Medicaid Asset Protection Trusts, powers of attorney, and avoiding a guardianship proceeding. So that's the elder law part. And the estate planning is the death planning, which has been defined, estate planning has, as getting your assets to your beneficiaries with the least amount of court costs, legal fees, no family fights. So smooth transition when the assets are distributed to your beneficiaries. We use trust to create order out of chaos, which can ensue without proper planning. Trusts avoid the pitfalls of wills by saving time and money in settling the estate, avoiding legal guardianship if you ever become disabled and can't manage your affairs, keeping assets in the bloodline instead of going to daughters-in-law and sons-in-law and their new families, protecting your home and life savings from going to long-term care costs, keeping control in your family and out of the court system. First reason why trusts have advantages over wills has to do with protecting you from a guardianship proceeding if you become disabled. Wills cannot do that. So talking about trust and lifetime planning is the opposite of what a will is. Just about everybody knows that a will is a document that is used when you pass away. So it's a death document only. It has nothing to do with disability planning. A trust is a plan for all 3 phases of life while you're healthy and competent, when you're sick or disabled, and after you pass away as well. So trusts cover all those areas, where wills are just for what happens when you pass away. The risk of a guardianship proceeding is an important risk to consider because a guardianship proceeding is where you are at the center of a court proceeding and someone has alleged that you're incapacitated. The chance of becoming disabled is about 50% at some point in our lives, and we are living longer. The biggest growing age group in America is 90 to 100-year-olds, and we're living actually 33 years longer than we did 100 years ago. So we call this a longevity risk, and our chance of becoming disabled is about 50%. If you don't have a plan that says what's going to happen and who's going to manage your affairs if you ever become disabled, then the state has a written plan for you, a court proceeding called a guardianship. The court can override who you chose as your power of attorney and appoint someone else as your legal guardian. The court chooses who your legal guardian will be, maybe even a complete stranger to you. If you are ever at the center of a guardianship proceeding and you become well again, well, you can't get back control of your affairs without a court order. So that means you would have to have some kind of hearing or trial to prove to the judge that you've gained control of your affairs again in your capacity. These proceedings may be expensive, time-consuming, stressful. The legal guardian may have limited options to protect your assets from nursing home costs, even though that might have been your goal. Conflicts may arise between what your family wants and what the guardian wants. So just about everybody knows it's good to avoid court proceedings, but this is one that's very invasive into your privacy and goes to the very heart of you being able to make your own decisions, your civil liberties, basically. A revocable living trust helps you avoid the guardianship proceeding if you become incapacitated. Unlike a will, a living trust takes effect while you're alive and stays in effect when you're disabled. The trust, if you create one, is in your name. You appoint yourself as the trustee or manager of the trust. Just about everybody knows that a will has a manager and it's called an executor. But when you have a living trust, you have a trustee as the manager. So by definition, a living trust is a trust you create while you're alive. Therefore, a living trust. And by definition, a trust is a legal entity that owns assets. If Mary Jones creates the Mary Jones Living Trust and she has a house, we will transfer her house with a new deed into the name of her trust. The new deed shows the ownership of the house and her property as Mary Jones, trustee of the Mary Jones Living Trust, dated June 21st, 2021, or whatever date she signed the trust. When Mary creates her trust, she also names someone else as a backup trustee in case she becomes disabled. Now, usually that person is her spouse or one or two adult children or someone else she knows and trusts to do a good job for her. This way, the people that you know and trust are in control of your affairs during disability, not a legal guardian appointed by a judge. You may take back control when you recover. So if Mary's in a coma and she comes out of her coma, she just steps back into her shoes as her own trustee, no court proceeding required. And if there were ever a guardianship proceeding, the court cannot override your trust. It guarantees you get the people you choose in case you're ever disabled. Another important disability planning document is the elder law power of attorney. This is the document that we as elder law attorneys and all other elder law attorneys have our clients sign. And it allows us to help you save money from nursing home costs. It's stronger than the standard form. We call the elder law power of attorney the prescription strength power of attorney. It's used to transfer and protect assets in the event of disability, and it has unlimited gifting power in it, which is the key to allowing us to save about half of the assets of a single person who might need a nursing home, and their money is going to go to the nursing home. We can still save half of it, even on the nursing home doorstep. So it's an amazing tool that we have in New York State. that's not available in all other states. Some states might have it, but not all states. And this is referred to not only as the gift and loan strategy, but also as half a loaf planning, because as we know, half a loaf is better than none. The second reason why trusts protect you better than wills do and have advantages over wills is that trusts protect you from probate court proceedings on death. Wills do not. Probate, the term, means to prove the will is valid. So a probate court proceeding happens when wills go through court. A common misconception about wills is that if you've signed your will, it's so clear what you want. Why would there need to be a court proceeding? But that's not how wills work. It's not that wills are bad. It's just they're very specific legal documents used in probate court if you die with assets in your name alone. So if I own a house and I die, my house has to go through probate court before my children can get it because it was in my name alone. So that's how wills are used. Now, when your will ends up going through probate court because you died with assets in your name alone, the court has control over the estate through the judge. The executor may not act until approved by a judge, which may cause lengthy delays in getting access to money and other assets. So, for example, if the stock market and the real estate market are nosediving and the executor wants to sell those assets now to prevent further devaluing of those assets for the beneficiaries, well, the executor cannot do it until they get permission from the court. The probate court proceeding may be costly, time-consuming, stressful, and in terms of cost, there's also the social cost or the relationship cost. Because, for example, if you die and your will says, well, I leave everything to my two children, but that third child doesn't get anything, that third child can contest the will. They're included. Even if you leave them a little money, they can contest it. And that can force a long, protracted litigation called a will contest, which often leads not to a trial, but to a settlement where the disinherited child gets money, even though the will said they didn't. So this kind of terrible litigation situation, it creates a war among family members, and it can lead to broken relationships for life in a time when it's a grieving process, yet there's all this conflict going on. Wills are also public records. Anyone may see what you had, who you left it to, go to court and get a copy of everything. The benefits of revocable living trusts are that they avoid probate proceedings entirely for the assets in the trust. So this saves the time, legal fees, and court costs of assets going through probate court. It is estimated that lawyers usually charge around 3% to represent the executor of an estate going through probate. But if it's a trust and the trustee hires the lawyer, usually they charge 1%. Now, some lawyers hourly bill, so you didn't even know how much they're going to charge, but it's a 2% savings on legal fees, usually by using trust versus will on the settlement of the estate. When you have a trust, you avoid court control of your estate. On death, your backup trustee may act immediately without need for court appointment to distribute the assets to the beneficiaries. Trusts are also private. Only the people you name in the trust have a right to see what's in them, and trusts are much harder to contest. So it's not the norm, but sometimes there's a child who's not getting as much for some reason. So in a case like that, a trust is usually a better option to avoid those conflicts that can happen in a probate proceeding. It was in 1991 that AARP said that most families should be using trusts, not wills. AARP studied probate court. They knew all the money that was being wasted on doing probate when all that money and effort and time and family relationships could have been preserved had the family only done a trust. So when this study came out, that started what's been referred to as the living trust revolution, because now the middle class never before started using trusts. It was no longer just for the super wealthy. There's also the multiple probate problem. So if you were to die a resident of New York State, for example, nothing's going through probate court, and you also have your condo in Florida, but it's in your name alone. Well, when you pass, there will be a court proceeding in Florida where the condo is located, and that triggers another probate proceeding in New York. So now you have two probates, one in New York when you really shouldn't have had one, but because you have one in Florida, you have to do one in New York as well in your home state. This is called the multiple probate problem. And instead of having to probate in every state where you own real estate, if you have a trust, you may deed your property from any state into your same trust and avoid the multiple probate problem. So this saves time, it saves money, it saves aggravation for the people you leave behind to settle your estate. It's a gift to all included, the beneficiaries and the trustee. The third reason why trusts have advantages over wills is because trusts protect the inheritance you leave from your children's divorces, lawsuits, and creditors, and keep your assets in the bloodline for your grandchildren. Wills do not do that. So a couple examples we go over here and a couple benefits about protecting inheritances for your children. The first example here is the second marriage, or third or fourth. We are a very romantic species, and it is not unusual later in life for people to fall in love again and get remarried. So a very common example, and one of the reasons that this is so important is because second marriage planning requires careful balancing between the needs of the surviving spouse versus the children from your previous marriage. So a very common example is two people meet up later in life. They don't have any joint children, and they're not going to have any. They're in their golden years now, and they each have their children from the past. They pool their resources, they buy a house together, and they own it jointly. The thought being and the goal that when they both die, the house gets sold and gets split between their two sets of children. But the problem is the survivor wins, because if one spouse dies, the surviving spouse owns the house 100%, could change their will and leave it all to their own children and leave the other kids out completely. Or who knows, leave it to their new spouse they met at the senior center and got married again. Again, romantic species. So in a case like that, that new couple, after getting married and buying the new house, they could transfer that house into their joint trust. When the first spouse dies, another co-trustee comes in to be co-trustee, with the surviving spouse. Now we have a gatekeeper, someone who will protect the plan and prevent it from being looted so that both sides of the family are protected and both sets of children's inheritances go to them. We have a lot of ideas for the second marriage. This is just one of them. And the point is that you do have to be extra careful with second marriage planning. Also, trusts protect the inheritance from your children's divorces, lawsuits, and creditors, and keep assets in the bloodline. Here, we're talking about the Inheritance Protection Trust for your children, one for each child. Now, generally speaking, our wills say, I leave everything to my children equally. And then when you pass away, each of your children gets, if you have 3 children, they're 1/3. The problem is if one of the children gets their inheritance and dies fairly soon after you, still having their inheritance, and is married, who do you think gets their inheritance? Well, usually their spouse, who could then later fall in love with someone else, has the money, and the money may never end up with the grandchildren or your other children, like maybe how you would have preferred it to go. So instead of leaving everything directly outright to your children, you leave it to a trust for your son or daughter. The son or daughter may be the trustee of that own trust. Remember, nothing goes in the children's trust until you're gone. It's just for when the inheritance comes to them. So your child can be the trustee of their trust, and they can spend whatever they want. So you're not ruling from the grave. There are no strings on it. You can put strings, but not usually is that done. It affords protection from your children's divorces. The divorce rate is 50%. We know it's a chance. So that way, the money that you leave to your child in their inheritance trust will not go to their divorces. It also gives protection from their lawsuits and creditors because it doesn't use their social security number. It has an EIN, and it's not their money. It was your money you left to them. So it's lawsuit and creditor protected. The Inheritance Protection Trust also affords protection against the beneficiaries, from lawsuits and credit. Sorry, I got mixed up in the wording here. So it affords protection from assets going to in-laws and their families, and I'll talk a little bit more about that in a minute. And it can give protection against the beneficiaries themselves, which means, say you have a child who is not that good with money, has had financial difficulties. So this way, with another trustee rather than the child, or a co-trustee with the child, then the money won't be spent foolishly. So another issue is, well, you leave the inheritance to your children, and yes, it's protected from their divorces and creditors, but what about your grandchildren? So when a child dies, having the inheritance, or even before you die, the share you were going to give to that child goes to their children. So your grandchildren by that child for their health, education, maintenance, and support. Now, if your child dies and doesn't have any children, well, then it goes to the other siblings' trusts. And if they had predeceased, it goes to the nieces and nephews of your child, your other grandchildren. So in other words, it goes to your children, then to the grandchildren. You may choose to leave a percentage to a beloved in-law, such, not normal. Most people don't leave any money to their daughter-in-law or son-in-law for the reasons we've just talked about, them getting remarried. But sometimes it fits the bill that you want to leave some money to your beloved son-in-law or daughter-in-law. But in that way, you can structure it so that they get a stream of income from a certain percentage, like half maybe. And when they die, it goes back to your grandchildren. So all those are choices. This way, your careful planning continues for decades after your lifetime. The fourth reason why trusts protect you from better than wills is because a certain type of trust protects your assets from long-term care costs. Wills do not. How could wills possibly protect your assets from long-term care costs? They only take effect when you die. Excuse me, I'm going to take a drink of water. Thank you. Now we're talking about the Medicaid Asset Protection Trust, or IM, and that's referred to as the MAPT, or the Medicaid Trust. With the Medicaid Trust, you place your home and certain other assets into the Medicaid Trust, and now you can qualify for Medicaid benefits to pay for those expensive nursing home costs after the assets are in the trust for 5 years. There's that 5-year look-back period that you have to plan ahead to get that protection. So this is a specific type of trust. There are different types of trusts. They say different things. They have different rules within the language in the trust. And this Medicaid trust has 3 rules, or 3 roadblocks that Medicaid cannot break through. So number 1, it's an irrevocable trust. But don't get scared off by the word irrevocable, because in New York, you may revoke irrevocable trust by agreement of all the parties, which means the parents and the children usually. And you can change who the beneficiaries are. You can change who the trustees are. So it's quite flexible. The second rule of the Medicaid trust is that you must name someone else as a trustee, usually 1 or more adult children. It doesn't have to be children. It just usually is, because we're saving the money for them. That's in the Medicaid trust. And so we name 1 or 2 of our adult children as the trustees, but we can always change who they are. We can eliminate them and add a new one. We can substitute trustees. So there's a lot of protection there for your own autonomy, and you're still in charge. You also don't share assets or creditors with your children. So there's no mixing up of your legal, business, and financial lives. The third rule of the Medicaid trust is that you must limit yourself to income only, such as interest on CDs, dividends on stocks, and I'll tell you in a bit how you can use some of the principal, but this is an ironclad rule in the trust because if you even had the right to get some principal from the trust, it means the nursing home could get all of it. So the concept of the Medicaid trust is that you put your home and certain other assets into it, and then you qualify for Medicaid benefits after you're past the look-back period, which is 5 years. The main difference between the revocable trust that Mary set up and this Medicaid Asset Protection Trust is nursing home protection. You don't get that with a revocable trust. It's only with the irrevocable Medicaid trust. The Medicaid trust does not affect your lifestyle since you still receive all of your income like normal. Your Social Security, your pension, your IRA distributions, that's all your money. This trust does not have anything to do, with income. It's about asset protection only. But your income all comes to you like normal and does not go into the trust. So the Medicaid trust makes sense for the assets you're not going to spend, like your home and investments, whether you're taking income or not taking income from your investments. You have the exclusive right to use and enjoy your home. What that means is that you still get your STAR and any other real estate tax exemptions you now get. That all stays the same. You pay your taxes like normal. You also have control over your trust by retaining the right to change trustees at any time. Medicaid can only look at the income from the trust and protects the nest egg for your children. Also, you may sell your house at any time. It's a very common question and event, actually. Later in life, you don't really need that big house anymore. You sell the house. The money from the sale stays in a bank account in the name of the trust. Although you cannot spend it, you can use that money to buy a new house, downsize, buy a condo or a smaller house. And now the new house is also protected the same amount of years as the old house was. There is a 5-year look back for facility care, which is nursing home cost care. And there will be a new 2.5-year look back for home care that never used to exist before, but it's coming soon. So the Medicaid trust has an effect on getting community Medicaid, which is in the home as well. It's not a substitute for 24-hour care in a nursing home, but sometimes that's all that people need is a few hours at home. You may gift principal to children and grandchildren. Now, remember I said you yourselves can't get the principal, but you can gift it to a beneficiary who could pay for something for you, or just give it for gifts. You also can use money in the trust to pay for real estate taxes, home maintenance and repairs, and home insurance. We recommend not doing that because why would you want to spend down the money in the trust that you're trying to protect for the children? But for some people, it might be necessary because they just don't have enough cash outside the trust. Also, in New York State, IRAs, 401ks, 403bs, and other types of qualified retirement funds are protected from going to nursing home costs as long as you're taking the RMDs. So we say they're exempt. The word exempt means they don't look at it. So it always pays to get started. If you don't make the 5 years, you only have to pay for the time left. Now, some people won't have the money to pay out a year or two, self-pay the nursing home before they apply for Medicaid. So we have other choices. We have certain assets that are already protected for married couples, like the house, plus about $130,000 up to. We also have spousal refusal, which allows the spouse at home to keep more. That won't go to the nursing home. And for single people, like I said before, we have the gift and loan strategy or half a loaf planning, where we can save about half usually. So there's always options. Our job as elder law attorneys is always to find a way to save the most amount of money possible for the client when they need a nursing home. And of course, nobody wants a nursing home. Nobody plans on it, but they're full. And nursing home costs go up to $20,000 a month in some downstate places, even upstate New York. I've heard they're up to $18,000 a month in some places. So with those astronomical nursing home costs, The Medicaid trust is a way to preserve more of your assets for your family and less for the nursing home. A word about estate tax planning for larger estates. This is not going to affect all that many people, but it will affect some people. So we like to tell you a little bit about it. So with estate tax in New York, there is about a $5.9 million exemption, which means that if you are under that, you don't pay any estate tax. But even if you're over a little bit, you'll have estate tax on a $6 million estate. Your family owes about $500,000 in estate taxes that goes to the government and not to them. If you have a spouse, we have a two-trust technique where each spouse sets up a trust, and with special language in the trust, estate tax savings language, we can double the estate tax exemption to $12 million rather than $6 million. So it's very, very helpful for some couples. Your estate tax savings start at $500,000 and go up to over $1 million, depending on the size of your estate. In conclusion, estate planning with trust creates order out of chaos. Trusts avoid a guardianship proceeding on disability, keep control in the family, and give you asset protection options that you might not have in a guardianship proceeding. Trusts avoid probate on death. They keep control in the family. You save significant time and money in settling the estate, and you keep your affairs private. Remember, wills are public. It protects, trusts protect the inheritance you leave from your children's divorces, lawsuits, and creditors, and then pass it by blood to your grandchildren instead of to in-laws and their new families. And trusts protect your home and life savings from long-term care costs and make you eligible for Medicaid for home care and nursing home care when you need it. We have a unique planning process at our firm. It starts today with this webinar. We also give you a free initial consultation, absolutely free, no pressure is put on you in any way. We will do a free review of your existing plan if you have one. We give you a free copy again of Michael Ettinger's book, Elder Law Estate Planning. You do not have to buy it and read it before you come in for the appointment. We don't recommend it. We recommend come in for the appointment, come to the webinar like tonight, come in for the free consultation. We give you the book. We write down some of the key chapters to read that apply more to you. And we give you a fixed fee quote, flat fees. Our fees are not based on a percentage of your assets. We'll let you know what we think you might need in a plan, maybe nothing, maybe just power of attorney and a healthcare proxy for now. Some people do wills, some people choose trusts. This is not so much about you need a trust. This is more about this is how different they are and what fits your needs better. So we are very clear that first day. I mean, occasionally there's something that needs a little more research, but we are fully transparent in what we're recommending and telling you how much it would cost and what it would include. Then there's a second free follow-up consultation to have your questions answered. We draft the plan together if you've decided to go forward. Now, there's no pressure to do that. We like you if you do a plan. We like you if you don't do a plan. It sometimes takes people years to make up their mind. But if you are ready to go forward, drafting the plan means me asking you a lot of questions about who are your beneficiaries, who gets what, who's the trustee or the executor, who are your agents on the power of attorney and the healthcare proxy. There's a lot of questions that go into it. We give you a detailed written proposal for the fees quoted. The choice is yours to go ahead. There's never any pressure whatsoever. There's no retainer agreement for you to sign. No fees are due until after the documents are signed. So then there's the signing date, the final meeting to review and sign the documents. Now on that day at the end, that's when you pay. Now that's not the norm for most firms. A lot of firms will ask you to pay half up front, but we don't do that. We don't require that you make a commitment until you've actually signed the plan you asked us to create, and that's when you pay. So the credit cards are accepted, Visa and MasterCard, when you pay, and you may pay all at once or two payments over 60 days. No, two payments over 30 days or three payments over 60 days. And there's no fee for the payment plan. Now, our firm has a process trademarked, by the way, by Mr. Ettinger, even after you sign your documents. We don't say goodbye, we say welcome to the firm. Our process, this trademark process, means that we keep you up to date of law changes and other matters through our weekly Ettinger Elder alerts. These are emails, but we call them alerts, and they're all about keeping you updated on law changes, also financial matters and health matters sometimes as well. But this way you keep up on any law changes. And then we also give you a free review of your estate plan every 3 years for changes in your health, assets, and family, births, deaths, marriages, divorces, relationships within the family. Those are and how you've titled all your assets. Those are the things we go over in your 3-year review usually. We never charge for phone calls, voicemails, or emails, or any of the questions that are asked. By using this program, your plan is never more than 3 years old, and it works when you need it, not just the first time you sign it. So to schedule your free consultation, there are options. We say the free consultation is a $500 value because that's what a lot of firms will charge you for the free consultation, and say, well, we'll apply it, to your fee if you go with us. But, that's sort of like trying to entice you, and we don't do any of that. There's no enticing. It's a free consultation to give you adequate legal advice for your situation. I really do hope you come in and see me. Like I said, I didn't go to law school until later in life, and it's a real, I feel it's very gratifying to be able to help so many families do their planning. A lot of what we do is crisis planning, but most of what we do is pre-planning, where the crisis hasn't hit yet and you're trying to avoid all of the chaos of a crisis. When you come in for your consultation, it'll be with one of our experienced elder law estate planning attorneys. Again, my name is Bonnie Cram, and I work out of the Saratoga, Albany, and Middletown offices. We also have offices in Rhinebeck and Fishkill, and James Asquith is a very experienced elder law estate planning attorney who works out of those offices. You're welcome to go to any of the offices, but those are the ones I go to, and James as well. The consultations are available either in the office by video or by phone. You may schedule your appointment online. Oh, I want to go back. So the Saratoga office, our name, our Ettinger Law Firm name is not on any of the buildings where we practice law. In Albany, we're at 125 Wolf Road, next to Denoyer Chevrolet, across from Denny's, on top of the M&T Bank building. We're on the second floor there. In Saratoga, we're at 340 Broadway, which is down by the park. We're on the third floor there. We're across from Starbucks, next to Eddie Bauer. And in Middletown, we're at 75 Crystal Run Road, which is next to the State Police Barracks on one side, Blue Cross Blue Shield on the other side. And the important thing to remember about the Middletown office is that we're at the back of the building because we're on the ground floor. And so you need to drive around to the back of the building to come into the hallway that comes to our office. Let's see, the other office addresses are 6369 Mill Street in Rhinebeck. We're on top of the M&T Bank building there on the second floor. And in Fishkill, we're at 200 Westage on the second floor there. Remember, our name is not on the building, but the numbers are prominent. So these are the ways that you can schedule your appointment. You can use our Calendly link, which we will email you tomorrow. It's kind of, help guide you through it. You can also call Patty Brown at 800-500-2525, extension 117. Patty's been with the firm 25 years. She's very knowledgeable. She'll take good care of you. She's very nice. And so if you prefer speaking to a human being, you may call Patty. You can also email Patty at pbrown@trustlaw.com, Or we also have a texting way to make an appointment. You would text free C for consultation, to 631-515-0034. And then that'll set you up to make an appointment that way. So any of those ways work. And I do hope you come in to see me. So that's the presentation part of the evening. And now we can go to the questions. So as you can see at the bottom, there's a chat. I'm assuming you can see what I see, a chat button and a Q&A button. And those are ways that you can type in a question and then I'll answer it. Well, I definitely hope you come in and see me because there's no obligation. It's really, I look at it that you're doing your due diligence to explore, learn, have a lawyer tell you, well, these are the options, and go through the whole list of the possible goals that you might have. We actually ask you to fill out a form before you come in. Some people do it, some people don't. It really doesn't matter. But filling out the form ahead of time is definitely an easier way for both of us really to go through everything. But we also can fill it out at the time that you come in and meet with me. Well, the other thing that's good to know is that we do New York law. Sometimes, for some reason, we have people from other states, so we do New York law. And for most planning purposes, you do have to, be a New York resident and have a New York licensed attorney to do that planning for you. All right. Well, thank you so much for joining the webinar tonight. We will send you a recording of the webinar tomorrow, along with the booklet, the e-booklet, Elder Law Estate Planning in a Nutshell, and I hope to see you soon. Please come in and see me.